Hello, welcome anyone who is now attending the Beverly Hills Bar Association Real Estate Section program for today. I'm Joe Cobert, be the moderator of today's program. I'm a real estate attorney with a specialization in real estate finance, a past chair of this section. We have an executive committee and it's co-chaired by Howard Gould and Elizabeth Dryden. I'm still on the executive committee. We would love to have more real estate attorneys and others on that committee because that's where we generate the programs and get the speakers, which we try to have about 10 months out of the year. The program materials, hopefully all of you have received them. They were emailed about an hour ago. If for some reason you didn't get the emails, check in your spam folder. If they did come to you and you just didn't access them yet, you can download from the link at any time during the program or after. And so don't hesitate. Wonderful material there. As far as questions, we're going to have question and answer, but send the questions, if you would, to the Q&A function at the bottom bar. Don't send them to chat. We will look at them and try to select some good ones. And you're seeing as well the notification from our expert video and audio person from the Beverly Hills Bar. Your microphones have been muted. There will be a question and answer session at the end of the program, but we're not going to have people getting up and raising their hand and giving questions. We'll select them from the Q&A portion. Now let me get to our esteemed speaker. It's Bruce Gibner. He has some wonderful credentials. They're so extensive, I can't give you all of them by any means. He's been a tax attorney for an excess of 35 years. He's presently of counsel to the law firm of KFB Rice. They're based in Torrance. And he's been a super lawyer as long as there have been super lawyers here in Southern California. He received his undergraduate degree from UCLA and then went east, getting his JD from Columbia Law School, Columbia University, and an LLM in tax from NYU. He stayed in New York for that period of time. But fortunately, he's come back to the West Coast. And Bruce is a prolific writer and speaker. Of what I know, he's published at least 6 books relating to tax matters. For those of you who are aware of or work with continuing education of the bar, Bruce has told me that he's written about 17 chapters of different books, so very widely known there. And he's published in professional journals over 100 articles. So we've got a real specialist, and it's a privilege and honor to be able to introduce him to talk about our topic, which is alternatives to 1031 exchanges. Capital gains planning in the real estate area. Bruce, take it away.
Thank you, Joe. You just made me a decade younger than I am, which is terrific. So I've been practicing for 35 years and it's 45. But I appreciate that. Also, yes, we have an office in Torrance, but I am here at Bundy and Wilshire in West LA. So thank you. It's always a pleasure to have the opportunity to speak to the Beverly Hills Bar Association. Today, we're going to cover ways to reduce the FER and in some rare cases, eliminate capital gains taxes. Can you see my outline now, Joe, on the screen?
Yes.
Okay. We won't be talking about Internal Revenue Code Section 1031 exchanges because, in fact, our firm has very little to do with Section 1031 exchanges. Why is that? Our practice is about 60% wealthy real estate families, and a wealthy real estate family is one that either buys and holds or builds and holds, and they never sell. So as tax lawyers, sometimes we help other people's clients with tax issues related to 1031 exchanges, for example, the ever-present drop and swap and other such issues. We once issued an opinion letter that a 27-year lease was the equivalent for 1031 purposes of a fee interest. which is interesting because you read the regs under 1031, it said the reg says that a 30-year lease is equivalent to a fee interest, but the regulation does not say that a less than 30-year lease is not equal to a fee interest. So client was happy with our opinion letter. So our firm has 7 tax lawyers. We deal primarily with 4 taxes. And in order of difficulty, the first one is estate taxes, which are purely voluntary. The only people whose families pay the estate tax are those who fail the plan. When I graduated from Columbia, one of my professors, George Cooper, wrote an article which you can find on the internet. It was in the Columbia Law Review, entitled Estate Taxes. No, it was entitled Voluntary Tax, or quotation marks, the estate tax. And it was voluntary 45 years ago. It's still voluntary today. I can make a 10 million, 100 million, or $1 billion estate go to zero. It's not really very difficult to do. Capital gains taxes is the next, is the biggest area of our practice. Capital gains taxes are not voluntary, but as we'll discuss today, there's a dozen. We're not going to cover all dozen because not all of them are available for real estate, but there's at least a dozen ways to reduce the fee and in some cases eliminate capital gains taxes. The next biggest one that we spend time on is the tax on passive income. So apartment buildings, stock portfolio, closely held S corporation or LLC that operates a business, you can reduce and in rare cases eliminate the tax on passive income. The last one is the tax on earned income. That's the most difficult of all. You can reduce it, you can't eliminate it. So what's the tax on what's earned income? The salary from a business you don't control and income from a retirement plan or an IRA. Yes, we can reduce that. So what are we going to do today? We're going to review the 4 criteria that we use to choose among the dozen or so capital gains tax planning structures. We're going to review the non-statutory doctrines the IRS and the FTB use to challenge capital gains tax planning. We're going to talk about the penalties briefly that the IRS and FTB can assert against capital gains tax planning. We're going to talk about the incidents and the identity of the auditor. We're going to talk about the 4 tax shelters. And we're going to talk then about 7 techniques, not all of the ones, that we can use before a sale. We're going to talk about 3 techniques you can use after a sale to reduce the tax. And as I said, we're not going to discuss what I call the crown jewels. We only discuss those when someone's paying me $12.50 an hour as a client. What I've learned in 45 years of practice is that if you have a good idea, shut up. So a lot of people never learn that lesson. Any event, so here we are in the outline. So what are the 4 criteria that we use when a client says, I've got a capital gain event? The most important one is timing. We want someone to come to us this year, 2022, for a capital gain that's going to occur in 2024 or later. That's the best. Timing is the most important element. The farther in advance you are of a sale, the better it is, the more alternatives, the more conservative the alternatives, the safer it is, the tastier the alternatives. If they won't come to us 2 years in advance, then let them come to us in 2022 for a transaction that's going to occur in 2023. Well, if someone comes to us in 2022 for a transaction that might occur in 2022, there's some things we can do, but I got a call the other day. The guy said, okay, well, I'm selling, I'm in escrow. I said, have all the conditions closed for the purpose of the escrow to close? He said, yeah. I said, no, the escrow, for tax purposes, the escrow is already closed. He said, no, it's got a month to go. I said, no. You may have a month to go for real estate purposes, but for tax purposes, the escrow is already closed. So timing is the most important, okay? And a lot of people just come to us when, my escrow closes next week. Nothing you can do before the sale. There are things you can do after to ameliorate the tax result. Next one is the size of the gain. Why is that important? Many of the structures that you use to reduce or defer the gain are based on the installment method of accounting. Everybody instinctively understands the installment method of accounting. If I say to you, you've got a $10 million asset with a 0 basis, that I'm going to pay you $1 million a year for the next 10 years, you understand you're going to pay tax on the $1 million a year of gain that you get each year for the 10 years. Or if I give you a 30-year amortized note, you know you're going to pay tax on the principal as you get it, and there's less principal in the first 10 years than there is in the last 10 years. So everybody instinctively understands Section 453, which is the installment method of accounting. However, what most people do not know is 453 capital A, not small a in parentheses, but capital A. Between 453 and 454, Congress ran out of code sections. So they shoved, I think, 453 capital A, capital B, and capital C between 453 and 454. And 453 capital A has the rule that most people don't know. It's the $5 million limit on how much in installment notes you can create per year. So each person can only create one $5 million installment note per year, $10 million per couple. So say Bruce and Kathy Gibner sold something for a $10 million interest-only installment note. It doesn't have to be interest-only, but let's say it's a $10 million interest-only installment note. The rule 453 Cap A does not apply because it's two people, 5 million and 5 million. Change the facts. Bruce and Kathy Gibner sell something for $11 million. Aha. The 11th million, let's say the tax in there is 33.3%, 20% federal, 13.3% state. What the rule is you look inside that million, you look at the tax, $333,000, and you pay, it's in this note here on the page, you'll see it right there. You pay the short-term rate, which this month is 3.05%. That's the applicable federal rate, plus 3%. So you go, oh my God, I don't want to pay 6.05% non-deductible on $330,000 for that 11th million. So in fact, no one does a note that's greater than $10 million per couple. Now, are there ways to multiply the 5 million per person? Of course there are. There's lots of ways, but I'm not going to talk about all of them, but a simple one is, let's say Bruce and Kathy have an asset that's going to go for $20 million. What do? Set up an irrevocable trust for Matthew and Alex, our son and daughter, transfer $10 million of value in there. We have a $24,120,000 gift exclusion. So transferring 10 million in there doesn't create a taxable gift. Now the Alex and Matthew trust sells for a $10 million interest-only installment note. That's one way to double your pleasure and double your fun, right? What's another way to do it? We do this all the time. We create the $10 million note for Bruce and Kathy in September of 2022. And then in January of 2023, we do another 10 million. There's more, but it gives you an idea that there's ways to deal with that. But most CPAs have never heard of 453 Cap A. Okay, so timing, size of the gain, nature of the asset. Why is that important? S corporations have their own issues when you're doing a sale. C corporations have their own issues, the double tax. What about professional corporation stock? We're selling a medical practice right now for $40 million. Well, can't sell that stock to a children's trust. Doesn't work. What about, we have a franchise right now. Franchise or won't let us transfer it to a children's trust, but that's what we're doing. How do you deal with that? What do you do if you've got stock options to a key employee? Look at the stock option agreement. It's non-transferable. How do you deal with that? So there's all sorts of things that come with the nature of the asset. So timing, size of the gain, nature of the asset, and last one you don't think of, which is the speed of the increase in the value of the asset. So if you've got an asset of stable value, the guy says to me, or the couple says to me, hey, our apartment building's worth 20 million. We're going to sell in a couple of years. Well, the apartment building in a couple of years is going to go for, it's worth 20, it'll go for 25. It's not going to go for 80. So an apartment building typically is an asset of stable value. If you've got a business that makes, metal picture frames and it's worth 20 million, in 2 years, it's not going to go for 60. But there are assets, right, where client says to you, today it's worth 10 million, and next year it's going to go for 100. I mean, those kinds of assets exist. So when you've got an asset that's skyrocketing in value, there are techniques specifically for that kind of asset, which are the ones we tend not to talk about. So those are the 4 criteria. Okay, What are the doctrines? The IRS and the FTB can say, nope, we don't like that structure you just set up. Well, they come from this 1935 case called Gregory versus Helvering. There's a lot of cases with Mr. Helvering's name in it because Mr. Helvering was the commissioner of the IRS. But Mrs. Gregory basically tried to do a B reorganization, which should have been tax-free. And the IRS said, nope, you have an impure heart. You go, what? Wait a minute. She crossed all the T's, dotted all the I's, and she had an impure heart? Yeah, that's what happened. The hell? So you have all these, lack of economic substance, lack of business purpose, form over substance, step trend. So they have all these techniques they just throw at it. But that's why you want to set up the structure in 2022 and have the sale occur in 2024, because it's really unlikely the IRS and the FTB are going to throw those challenges if it's aged like a fine wine. Okay. What are the penalties? The easy penalty is 20%. That's the accuracy related penalty. Okay. And the IRS and FTB aren't saying that you're a bad person. They're just saying mathematically, the understatement of tax is greater than 10% or I think it's $10,000. So if you didn't pay tax on a $10 million gain and the tax is $3.3 million roughly, and the IRS says, nope, didn't work, and the FTB says, nope, it didn't work, then you owe 20% of $3.3 million. Now, there is a lack of economic substance penalty, which is 40%. Well, that's a little scarier. How do you avoid the accuracy related penalty? Well, there's 3 or 4 ways to avoid it. Reasonable basis, if you have a 20%, that's not a big number, it's a 33% chance of prevailing on the merits. As long as you file the IRS form 8275 disclosing the transaction, penalty doesn't apply. You have substantial authority, that's 40%, still not more likely than not. Get an opinion letter. And if you have a reasonable cause, it says reasonable case, that's a typo. Reasonable cause in good faith doesn't apply. What about audits? We tell the clients the audit rate is 100% and that the auditor is the Lord God Almighty. And if your structure, if you're not comfortable with a 100% audit rate and the Lord God Almighty, and if you don't believe in the Lord God Almighty, that's fine. Substitute the phrase an omnipotent, omniscient being. If you're not comfortable with that, and your transaction being on the front page of the Wall Street Journal, you have no business engaging in the transaction. So we are certainly prepared for that, or we don't want to be involved, okay? And some of the transactions, we require the client to get an opinion letter from an independent law firm. Now, in a lot of these techniques, you got to set up a trust for your good-for-nothing children as your partner in the planning. If you're interested, send me an email, and I will send you a handout we have called Maintaining Dictatorial Control Using a Children's Trust. Because when the client comes to me and says, you don't want to do capital gains tax planning, that's not their most important goal. It never is. Their most important goal is maintaining dictatorial control of everything from now till the day they die. Doesn't matter whether they're telling me they want to do asset protection planning, which we do, or estate tax planning. Their real goal is to maintain dictatorial control from now till the day they die. And no matter what kind of planning, asset protection, estate tax, capital gains tax, even many kinds of ordinary income tax planning, you got to have a children's trust. We show them that the children will get nothing until the parents are dead. And having a children's trust is like having the Bank of Cobert, BOC. Joe Cobert sets up a trust for his children, but basically he can do anything he wants with the money in the children's trust. So we tell clients about the 4 tax shelters: pensions, charities, charitable remainder trust, life insurance. What do the 4 have in common? All the money or assets inside of them grow tax-free. I usually start off by saying the phrase tax shelter has a pejorative connotation because you think, oh boy, that's a trust in the Cayman Islands on which people don't pay taxes on the assets in the Cook Islands Trust or Cayman Islands Trust. But there are 4 tax shelters that are no controversy. Nobody argues that a pension, charity, charitable remainder trust, life insurance, nobody would argue that those are tax shelters in the sense that they shelter the gains from current income tax. Nobody would argue that. The first 3, pensions, charities, charitable remainder trusts, share in common that all or a portion of the money or assets going into them, you get a deduction. Life insurance doesn't have that, no matter how hard insurance agents try to come up with ways to deduct life insurance premiums. Doesn't work. But life insurance has something the other three don't have. All the ways money comes out of an insurance policy are tax-free, whether it's the death benefit or parents are more interested in borrowing the money out tax-free. So one of the jobs of a tax planner is to help clients get money, buildings, into one of those four tax shelters. Not so much charities because you don't get a lot of benefit, but pensions, yeah, we get a lot of real estate and pensions. Charitable Manor Trust, oh, you bet we get a lot of real estate and Charitable Manor Trust. Life insurance, I'm not going to be talking about that today. So, okay. So we always start off with section 453E. What the hell is that? Congress said, well, here's what we don't want you to do. Joe Cobert has a building with zero basis, which of course is impossible, which is worth $10 million. And Joe wants to sell it and not pay tax on the $10 million capital gain, you know?
I tried.
Joe, I was going to say to Joe, and this is a technical tax term. I don't know how many of you people know this, but basically, manishtana ha-asset hazeh mikol ha-lefs. That's a technical tax term. So Joe doesn't want to pay tax on this $10 million appreciated asset with no basis because he knows, because he materially participates, the tax is 33.3%. Note that if it's a home, the tax rate is 37.1% because the 3.8%, the so-called Obamacare tax, which is a pejorative term, it's the net investment income tax, would kick it from 33.3 to 37.1. So Joe doesn't want to pay the tax on the $10 million gain. Sorry, my light goes out every 30 minutes. Come on. Come on, dimmer. Oh, there we go. So here's what Joe would really like to do. He wants to set up a complex trust, complex meaning it pays its own taxes, for the benefit of his good-for-nothing children. He sells it to the trust for his children for a $10 million interest-only installment note, 30 years. The children's trust paid $10 million. It sells it to the cash buyer. It gets the $10 million, pays no tax because it has a $10 million basis, and the money's in the Joseph Cobert Children's Trust. And Joe knows it's the Bank of Cobert. He can do anything he wants with that money as long as the note isn't paid off. So he controls the $10 million. That's perfect capital gains tax planning. There's one problem with it. What's the problem? You can't do it. Why can't you do it? Bottom of this page, section 453E. What the heck is 453E? It's the restriction on related party installment sales. Congress said, we don't want you to be able to sell something to a children's trust, as an example. It's a related party. And the related party turns around and sells it, has a basis of what it paid you, and pay no tax. Congress said, nope, can't do that. But when Congress wrote the rule, they put in a limit on the restriction. It's 2 years. So we said, not a problem. We'll accept the limit. We'll wait 2 years and 1 day or more before the Children's Trust sells the asset. What's the problem we have with that? Finding people who are coming to us who can wait 2 years and 1 day. But when we find them, this is the least expensive capital gains tax planning and is certainly among the 2 or 3 most conservative, and the clients love it because it's simple, it's conservative, and there's no one else involved. It's their own children's trust. It's beautiful. So what happens? Client comes to me, this is about 4 years ago. They bought their home in Beverly Hills 20 years earlier for $2 million. And of course, in 2018, they said, we're about to sell our home for $22 million. Can you help us not pay the tax on the $20 million gain? And I said to them, you know, it's a shame you didn't come to me 2 years and 1 day ago, because here's what I could have done. And I explained 453E, how we plan around the restriction on related party installment sales. They said, the husband said, I'm going to take the house. We're not going to put it on the market. Set up the structure and we'll wait 2 years and 1 day to sell it. And the wife said, but wait a minute. What if it goes down in value? And the husband said, it would have to go down an awful lot in value to make up for $8 million in capital gains taxes. So they didn't put it on the market. We set up the structure. They waited 2 years and 1 day and they sold it for 22, I think it was actually $23 million. So sometimes there's a bait and switch element to it. Sometimes the clients come to us and they just have an idea of selling, but there's no current sale and they don't mind waiting 2 years and a day. And very, very seldom when we set it up, does it end up selling before the 2 years and 1 day. In other words, selling to the Children's Trust doesn't prevent you from selling it earlier. It just means you won't get the benefit of the Children's Trust basis maturing to what it paid you, okay? So it's a wonderful technique. So the reason why I start with that is because 453E, what we next talk about is how do you deconstruct a transaction when you don't have 2 years and 1 day. Also, I teach this to all of our referral sources. I say, listen to when the client says, you know, I'm thinking of selling in 2, 3, 4 years. I say, stop, let's go see Gibner right now so you can start listening to the available structures, which are very conservative. So it's a departure point for when we talk. Oh, here's the diagram, okay? So you see step one, mom and dad or dad sells the building worth $1 million with basis of 0 for 100 grand down. We always do 10% down. Of course, that's a gift to the Children's Trust. Complex means it pays its own taxes. It's not the kind of Children's Trust we do for estate tax planning. When we do estate tax planning, it's a disregarded trust. Some people call it, and I hate this term, an intentionally defective grantor. There's nothing defective about a grantor trust. So you sell it to the Children's Trust. Now you're damaged, you're hurt, because in the year of the sale, you do pay tax on the down payment. But that's good. That gives it economic substance. So the Children's Trust gives back a 90% note, okay, paying interest. It's fully amortized for the 2 years and 1 day, and then for the statute of limitations on the sale, which is state is 4 years, federal is 3. We want the clients to wait 4 years. Once the statute of limitation runs, we make it an interest-only note. So it's about an 80 to 85% step up in basis. It's not 100% because you pay tax on the 10% down payment and you pay tax on the principal during the amortization period of 6 years. Okay. So once the 2 years and 1 day has expired, if you follow the dates here, then you sell it to the cash buyer. Cash buyer puts the money in the Children's Trust. You wait until the statutes run. The Children's Trust puts it in a single member LLC and the parents manage the single member LLC. So once the parents can step in to manage the LLC, they run the money. Once a year, they send a check up to the Children's Trust so it can pay them on the note. Other than that, the parents have everything. Now, what I included in here, I didn't do the entire handout we have on the structure, which is about 8 pages long, but say, how do the parents benefit from having the money in the heirs trust? Well, they can get principal payments on the note, which is nice because you're paying tax on the principal. You can increase the interest rate on the note. We don't want you to do that once every more than 3 years. The heirs trust can contribute the assets to the single member LLC, which we do so that parents directly control the investments. The single member LLC can pay the parent a salaries manager. The single member LLC can loan money to the parent. We don't like to do that because now the parent has the money, and if the parent gets sued, they could lose. The single member LLC buys the asset. That's what we want to do. Parents want to buy a $10 million boat. The LLC buys the boat. The parent pays rent to the LLC. The LLC sends the rent up to the trust, and the trust uses the rent to pay the parent on the note. If you watch The Lion King, one of Joe's favorite movies, right, Joe? The Lion King. What you learned in The Lion King was the great circle of life. What this structure is the great
circle of money.
Circle of money. The money just keeps recycling back to the parent. And of course, the last one is the single member LLC can invest in the parent's next deal. But in our clientele, basically, the single member LLC buys an apartment building. That's what happens with our clients. Okay. So this is the way the 453E works. How do you deconstruct it? Okay. Well, the rule is if you sell something, so here's what's something. Here, my chapstick. If you sell something, the chapstick, to a related party, and within 2 years, the related party sells this thing, that's 453E. So what the first way to deconstruct it is You sell something to the related party, and what you'll see is it's a limited partnership interest. But within 2 years, what the related party sells, what is sold is not the limited partnership interest. Now, this is not as conservative. Very few things are going to be as conservative as 453E. But to do this, we got to talk about what is partnership tax law. Most of you probably already know this, okay? It's the 754 election. So imagine that Joseph and I each contribute, this is how I explain it to clients. Joseph and I each put $1,000 in a partnership. The partnership buys a building for $2,000. Over the time, the building inflates from $2,000 to $5,000. At that point, I say, I'm done. Howard Gould comes along and says, Bruce, I'll buy your interest in the partnership. I say, building's worth $5,000. I own half. Give me a check for $2,500. Howard says, here's a check for $2,500. I leave. It's now Howard and Joe. Joe now says, yeah, I don't want to have the partnership anymore. I want to sell the building and dissolve the partnership. The partnership sells the building. Partnership gets $5 grand. Howard gets half, which is $2,500. Howard gets a K1 for $1,500 a gain. Howard goes, what the hell happened? I paid $2,500. I'm only getting $2,500. Why am I getting a K1 for $1,500? And Howard's right. When Bruce left, Bruce had paid $1,000. Bruce got $2,500. Bruce paid tax on the $1,500 a gain. So the 754 election is what when Howard bought in and Bruce's interest, he said, I will pay Bruce $2,500 if and only if the partnership files a 754 election. And what that did is it stepped up his basis in the building to reflect his outside basis, what he paid for the partnership interest. So that's how I explained to the client what a 754 election is, because partnership tax is the second most difficult area of tax law other than international tax, which is really difficult, okay? So what I explained to the client is we put the asset in a partnership and the parents are the 97% limited partners, and LLC owned by the Children's Trust is a 2% general partner, and the Children's Trust starts as a 1% limited partner. So what the parents do, and by the way, we want to put other assets in there also, but I'm explaining to you naked right now. We don't do it naked because it would look bad, okay? And the IRS could not like this structure. So we try to make it in a way that it has economic substance and that the IRS won't treat the partnership as an aggregate, because that would be deadly. We want the IRS to respect it as an entity and not apply the 1.701-2 abusive partnership regs. But that's the risk, and that's why this is not as safe as 453E. But in any event, explaining it naked, the parents now, let's go back to the $10 million zero basis building that Joseph has, okay? The parents sell 90% of the partnership interest to the Children's Trust for $9 million. We'll get to the discount in a minute. Children's Trust gives 10% down, $900,000, an $8.1 million note. Partnership files a 754 election. The basis in the building goes from 0 to $9 million. And a year or two later, you don't have to wait 2 years, it's not 453, but if you can wait 2 years, it's nice. The partnership sells the building for $10 million. Well, you got $9 million of basis, okay, minus depreciation that occurred. It's a very nice step up. It's about a 75% step up in basis because there's a 10% down payment. And what I left out is when we sell it to the Children's Trust, we actually give them a bargain. And the reason why we give them a bargain on the purchase is we want it to look like a state and gift tax plan, okay? So we give them a discount. We file a gift tax return for the discount, and we file a gift tax return for the money we put into the Children's Trust so it can make the 10% down payment. So it's not as good as 453E in terms of the step up, but it's nice, okay? So that's the partnership, because what you're doing is what you're selling to the Children's Trust, the related party, is a partnership interest. But what's being sold within 2 years is something different. It's the asset of the partnership. So does the IRS like this? No, of course not. And they issued a notice, I'm going to say at least 10 or 15 years ago, but they've never acted on that notice, at least as far as I'm concerned. I gave a speech at the Orange County Bar Association. Orange County Bar tax section on capital gains tax planning. And afterwards, a partner at tax partner, one of the 3 largest law firms in, at least at the time, a decade ago, in California, came up to me and said, "Yep, that's my favorite technique." He said, "I've seen audits by the FDP. I've never seen one by the IRS, despite that IRS notice." So I think that's it for using partnerships. Okay. I'm supposed to be looking at the Q&A. Why isn't the transfer of the $10 million building and children's trust a taxable event? Because this is aerial. Because it is, by the way, because the children's trust is making a 10% down payment. So that's taxable to the 10%. But if it's a 90% an installment note, okay, the parent's only paying tax on the principal inside the installment payments as they're being made. So typically Ariel would do a 30-year amortized note. So at least in the first 6 years, there's not a whole lot of principal. I hope that answers your question. Nancy says, could a children's trust structure be created for a non-child? Yeah, so we call it a children's trust, but obviously, Nancy, there's a lot of situations where there's no children. And so I explained to the client, I said, look, I'm calling it a children's trust, but just view it as an heirs trust. And because I explained, look, the word heir comes from the same Latin root as the word as the part of inherit. So inherit and heir, it's the same thing. So if I shot you dead today, you don't have children, but you have people whom you would wish to inherit. And there are ways to, sort of manipulate it. You can't, there's a limit on what you can do when it's an heirs trust that's a complex trust. So you got to be careful how you do that, or the complex trust can be a grant or trust. I don't want to go into that, but that's important, that you not make it a grant or trust. Anyway, so how do we deconstruct 453? Use a partnership. What's another way to get away from 453E? Okay, this is 453E diagram. So what you see here is Smith Properties LLC, which is owned by the Children's Trust. You see you drop the asset, the main appreciated asset, in the partnership right there. Okay. You sell the interest to the Children's Trust for 10% down, a 90% note. You get here's the 754 election. And then a year or two later, preferably 2 years later, doesn't have to be 2 years and a day, the cash buyer comes in and pays the partnership for the asset, and the Children's Trust gets the benefit of its step up in basis. So that's what the diagram looks like. I do use these diagrams to explain it to the clients and the CPAs or the other advisors. Sometimes it's a lawyer. Okay, so that's the restriction on related party installment sales, partnership to deconstruct it. What's another way to deconstruct it? Sell to an unrelated third party. Okay, well, there's 2 kinds of unrelated third parties. There are professionals and there are unprofessionals. And we have historically done both. So in terms of professional, there are 2 primary ones. One is, and this is a trademarked or copyrighted term called the Deferred Sales Trust. So if you Google Deferred Sales Trust, put it in quotation marks and drag down until you get to myept.com. EPT stands for Estate Planning Team. I'm not going to give you any history on them. There's a lot of history. Mr. Binkley created it. You'll see a lot of non-Binkley usage of deferred sales trust, but as far as I can tell, and I'm not an expert, I've never used them. I can talk about them because I certainly looked at it. But most of the people, I think, are just selling it because they make money when they refer it to myept.com. So it's not a statutory thing. As I understand it, and I'm being positive about it, I'm not criticizing them, so please take it that way. As I understand it, they have one lawyer and one CPA, and when you come to them, they assign one of those 2 people to you. That person sets up a trust for that person's children, okay? And that person's children's trust buys the asset from you. Let's use $10 million, okay? Let's assume it's husband and wife, so we don't have a 453 cap A, $5 million per person limit on installment sales, okay? So that children's trust, unrelated, gives you a $10 million interest-only installment note. It now has a basis of $10 million because it's not harmed by the restriction on a related party installment sales. It turns around and sells it and gets the $10 million of cash. So your $10 million of cash is in that children's trust, okay, which you don't control. I think they charge a 1% legal fee, 10 million, 100 grand. That's certainly reasonable to me. I think they charge a 0.3% trustees fee, which is not a big number. And I think they require a 1% money management fee, of which they get 30% and your money manager gets 70% of the 1%, something like that. Certainly not huge numbers. So what happens is the 10 million is in this trust. You can discuss with them how it's invested. They don't really care, as long as it's something that's going to return the interest that you've told them you want on the note in the first place. If you tell them you want 15% interest, they're going to have problems with that unless you show them, or you're going to make 15% interest. But basically what you're getting is on the $10 million with 3.3 of capital gains tax not paid, the 3.3 is in the trust. So let's say you're making 5%. So what is that? 165 grand a year. Now the trust is a complex trust, so it pays taxes at the highest state and federal rate. So what's that? It's about 50%. But at the end of 10 years, you've earned, the trust has earned money on the $3.3 million. So at the end of the 10 years, they say, do you want us to pay you off? Or do you want to continue it for year 2, 3, 4, 5? If you want to continue it, they'll continue it. But if you want to get paid off, they'll give you the 10 million. You owe the tax of 3.3 million. You get the benefit of the earnings on the you get the benefit of the earnings on the whole 10, right? But what you're ahead, of course, is the earnings on the 3.3 minus the taxes on the earnings that the trust had to pay. So it's not terribly exciting. They're not saying it's exciting. They're just saying, hey, your dollar's ahead and not a huge cost. Now, I've heard people criticize and say it's too costly because it's 1.3% a year for 10 years, and that's 13%. But a lot of people like it. They told me several years ago that at that time, they had $1 billion in various trusts, and they'd done 2,000 transactions in 20 years. So it must be that a lot of people like it. Is there a reason why the IRS and the FTB have not argued step transaction, lack of economic substance, lack of business? I don't know why the IRS hasn't done that, or the FTB. I saw a posting on someone's website where they said, oh, the IRS, the FTB doesn't like it. I haven't seen any manifestation of it. And the folks at Deferred Sales Trust said they had no problem on audit. I have no idea. I did see something recently, which if you email, I can send it to you. The state of Washington's Financial Institutions Division sent a cease and desist order saying that the note is a security and you didn't register with us. So they sent them a cease and desist order. Would the state of California do that? Yeah, probably. Why it hasn't done it, I have no idea. Okay. So this is a diagram of the Deferred Sales Trust. Here's the CPA or lawyer, set up a trust for their children, gives you the interest-only installment note, then sells the asset to your cash buyer and receives the cash. It's a pretty simple diagram. What's the other professional one? Oh, the other professional one is really cool. This one is very exciting. For that reason, the IRS doesn't like it. The IRS has been auditing Stan Crow, STANCROW. If you Google him, his website is Escrow Collateral. Get it? Escrow Collateral, Stan Crow. Anyway, very interesting structure. The IRS hasn't, as far as I know, the IRS has gotten nowhere in 6 years. In fact, the IRS has lost in court to Stan on some of the issues. The IRS is listed on its Dirty Dozen list, and the IRS has been underfunded for 20 years, as I'm sure you know. So what the IRS uses its Dirty Dozen list for is advertising. Because once it puts something on the Dirty Dozen list, people are afraid to do it. Even though the IRS hasn't won anything, but I can't recommend it now, even though I know you can get an opinion letter in favor of it. Even though I don't think the IRS has won any of the audits either, or prevailed significantly in any of the audits. So Stan's system is very simple. Let's say it's a 10 million zero basis asset. So you sell the asset to Stan, who's the dealer. He gives you back a 30-year interest-only note at specifically 5.61% on $10 million. So that's $561,000 a year. Stan then takes the asset, your $10 million asset, sells it and gets $10 million. I say to the clients, how do you like it so far? They go, wait a minute, he's got my 10 million. I say, okay, wait a minute. Now you take the note that Stan gave you, and what you do is you give it to the technically unrelated lender. It's a hedge fund that 15 years ago gave Stan $250 million. And the lender will take the note Stan gave you, 30 years interest only 5.61%, and it will loan you against the note 9.35 million, 93.5% at 6%. Well, it just so happens that 6% on 9.35 million happens to be precisely $561,000. Just coincidentally. So what happens is there's two escrows. Stan pays $561,000 into escrow one, which is for your benefit, but you never see the $561,000 because that escrow pours the $561,000 in escrow two, which is where you owe the lender. So you never see it, but it gets paid. So you walk away with 9.35 million in non-taxable loan proceeds. Now it works great if your basis is zero, but if your basis is $7 million, you would never do this because you're only getting 93.5%, so it wouldn't work. But if your basis is zero, it's a very attractive structure, okay? If Stan doesn't pay you off in 30 years, you don't have to pay the lender. It's a great structure. Ugh, could you do it? I don't know. All right, so what's the third one, the unprofessional one? Well, 453 has a definition of what's related. Well, who's not related? Aunts, cousins, nieces, and nephews. What we've done many times, 20 and 40 years. I guess I've been doing this for 35 years. I've been practicing for 45, but for the first decade, I was mostly a pension lawyer, pension and estate planning. So I started doing capital gains tax planning and asset protection planning in the mid 80s. So I've probably done 20 technically unrelated but friendly third parties. So the classic one is you've got a brother-in-law, and the brother-in-law sets up a trust for his children. So those children of your brother-in-law are not related parties. So let's say it's a 10 million, let's stick with the 10 million zero basis asset. Your wealthy brother-in-law makes a gift of $1.5 million to the trust for his children. 500 grand gives the trust substance, and the $1 million is used to pay you the down payment on the $10 million asset. Wait a year. And I'm leaving out, you want to give him a bargain deal so that on the sale for 10 million, his children's trust makes 500 grand. Well, if his children's trust makes 500 grand and it saves you 3.3 million minus 500 grand, which is 2.8 million, that's a terrific structure. His children's trust has to make a very healthy profit or it's going to lack economic substance. Okay, so let's move on to other stuff. What about charitable stuff? Well, for at least 30 years, people have been doing what used to be called charitable partnerships, mostly now are charitable LLCs. And the basic idea started in early 2000s. I think it was Arthur Anderson who was doing this scam. Let's take the 10 million zero basis asset. Joe would go to Arthur Anderson, I think it was Arthur Anderson, and they would say, no problem. Contribute this 10 million zero basis asset to an S corporation. You'll gift the 99% non-voting stock to that charity over there. The S corporation will sell the $10 million asset, have a $10 million capital gain. The K1 for 99% of the gain will go to that charity over there. Charities don't pay tax. Wait 2 years and then go to the charity and say, hey, charity, you're 99%. How about if I pay you $150,000 for your 99% non-voting interest? The charity says, 150,000 is more than I have today. You buy the charity's 99% interest for 150 grand. Is there a reason why the IRS might not like that? Can you imagine? So the IRS came out with, see right here, Notice 2004-30, and in 2013, Jay Adkison, who's probably the preeminent plaintiff's lawyer against asset protection planning structures, wrote an article in his Forbes column saying that a charitable LLC is substantially similar to that listed transaction notice. So what's the charitable LLC or partnership? Basically, it's almost the same thing. By the way, I use Joe not because of you, Joe, but Joe puts this $1 million of, here's the way we do it. We won't do it with appreciated assets because we think if you use appreciated assets, that is substantially similar to the listed transaction notes. So we will only do it for cash. So Joe puts $1 million of cash in this LLC or limited partnership, gives 98% of the 99% limited partnership interest in the charity, takes the deduction for that. My light went out again. And the deduction on $1 million isn't $980,000 because there's a discount for lack of marketability and lack of control. We try to keep the discounts as little as possible, but it's going to be at least 15%. So he gets some big deduction. It could be $850 out of the $980,000. So he saves taxes. Okay. What we want him to do is sit on it for a couple of years, 3 years, 4 years for the IRS and FTB statutes of limitation. And then after the time has gone by, he borrows the money from the partnership and he buys an apartment building. So if you do it that way, it's conservative. By the way, we require the clients to file an IRS Form 8086, which is a listed transaction notice. Why am I mentioning this to you? Because there's people out here who will do it for your client for appreciated property. I won't, but there are people out there who will, okay? They sell it all the time. Okay. Back to conservative. Charitable remainder trusts are in the face of the code, section 664. They're one of my 4 tax shelters: pensions, charities, charitable remainder trusts, life insurance. The problem with CRTs, there's several, but the initial problem is it's got to be real estate that's got no debt. So that gets rid of a lot of it, and it can't be a personal residence. So do we do it for personal residences? The answer is all the time. But we have to have the client pay off the debt on their personal residence because, you know, there's a lot of wealthy people that have very expensive homes, no debt on them. It's just like the 1031 situation. We have them move out, rent it for 2 years. We don't like 1 year. We're scared of 1 year, as we are scared of 1 year with 1031. We have them rent it for 2 years, and then they can contribute it to the CRT. And the charitable remainder trust is perfect because you get a deduction up front and you now have a tax shelter. The 10 million is in this charitable remainder trust. It earns money income tax free forever. Not only does it not pay tax when it sells the $10 million asset with zero basis. So you now have 3.71 million because the tax is 37.1. Well, no, if you change it to the rental, it's now 3.3 million. Okay. But so you're earning, you don't pay tax on 3.3 million. You don't pay tax for the rest of your life. You could be day trading. Okay. And you're going to get a cash flow of at least 5%. The older you are, the higher the percentage. The clients basically have one big issue, which is when they're dead, the money goes to charity. It doesn't go to their good for nothing children. However, if the children are all in their 40s, then you can do a multi-generation CRT. So it can go to the parents first while either parent is alive. And when the parents are both dead, it can go to the 3 children. When one dies, it goes to the remaining 2. When 2 are dead, it goes to the remaining 1. And when the one's dead, then it goes to the charity. CRTs are great. It's just, can you find the real estate that works with it? Here's some calculations you can look at. Okay, what can you do after the fact? Anything you do after the fact, by definition, is more conservative than something you do before the fact. Because what you do before the fact, the IRS doesn't like, or it wants to look for ways to challenge it. So can it challenge 453, the 2-year and 1-day restriction on related party installment sales? Really tough. You know, if you document it, you put 10% down. By the way, I've done some more, there's 20% down. If you wait 2 years and a day, very difficult for the IRS and the FTB to challenge it. I've never had one challenged, but that's not really meaningful. If you say to the client, says to you, how many times have you been audited for that structure? I say never, but that's not meaningful. I always say to the client, it doesn't matter that I've had never audited. It's meaningless. You have to assume a 100% audit rate by an omnipotent, omniscient being. Of the 80 billion in the Inflation Reduction Act, right, IRA, 47 billion is allocated to hiring new people. So not next year, maybe not the year after, but at some point in the future, the incidence of audit is going to go up. So you have to assume the audit rate's 100%. So 453E, I'm not really worried about an audit. I mean, if the audit, that's fine. I'm ready for it. You have to be ready for it. Charitable remainder trust, sale of capital asset. Now, has there been an audit of a CRT and a disallowance? Yes, the Ferguson case, 1999 Ninth Circuit Court of Appeal. Mr. and Mrs. Ferguson waited too damn long. They waited until the IRS, sustained by the tax court, sustained by the Ninth Circuit, felt that they transferred the stock into the CRT at the point at which the sale, it was a purchase by a bigger public company, a small public company, when the sale was practically certain to occur. Wow. And the Ninth Circuit Court of Appeals, on the second to the last paragraph, said, you're asking for comfort about when it's too late. We won't give you that comfort. No tax lawyer worth his fee would have advised the client to transfer an asset this late in an ongoing tender offer. The Ninth Circuit told the Fergusons to sue their tax lawyer. I have never personally read more chilling language in a Court of Appeals decision. But what it means is that charitable structures are by definition easier to do late than any other kind of structure. Because as long as when the asset goes to the charitable structure, whether it's, Charitable Llc, which I won't do for appreciated property, Charitable Remainder Trust, Charitable Lead Annuity Trust, which I'm going to explain to you right now, as long as at the time you transfer it, that you as the trustee are not obligated to sell, technically it's not too late. So I say to the clients, don't even list it for sale, let alone open escrow. Don't list it for sale. Don't hire an investment banker, let alone sign a letter of intent. Even though letter of intent non-binding is not too late, I wouldn't do it. In Yiddish, I wouldn't do it. So it's Lou Jacoby, may he rest in peace. So a charitable lead annuity trust is statutory. It's like a charitable remainder trust. It's a split interest trust. Split interest means there's two beneficiaries, the current beneficiary and the remainder beneficiary, a charitable beneficiary and a non-charitable beneficiary. In the charitable remainder trust, the current beneficiary is my client, the taxpayer, and the remainder beneficiary is the charity. In the charitable lead annuity trust, the charity is the current beneficiary and the remainder beneficiary is my client or the client's children. CLATs are really attractive. They really are nice. They're on the face of the code, 4947A1. What we typically set them up is the client puts in, let's say, $1 million, okay? The way we structure them, they're called shark fin CLATs, is the client puts in $1 million, the client gets $1 million deduction immediately. Why? Because in 15 years, the CLAT is going to distribute $1 million to some charity, okay? But because he's not distributing it to the charity for 15 years, he owes interest on the promise to the charity. Well, the interest rate is what's called the Section 7520 rate. It's the rate due for annuities, and this is an annuity. The annuity rate, the 7520 rate, is 120% of the mid-term AFR, which next month is going to be 4%. Holy crap. Back in January, it was 1.6. So on $1 million, the CLAT, you're the trustee of your own CLAT, has to distribute $40,000 a year sort of as interest to the charity. But if you make up a number, 9% for the 15 years, the million will double to 2 million. And at the end of the 15 years, there'll be 2 million in the CLAT, 1 million will go to the charity, that was your promise, and the other million can go to a trust for your good for nothing children, free of estate, gift, and income taxes. So I say to the clients, it's not a grand slam home run. In fact, there's no ordinary income tax plan that's a grand slam home run. If you find one that is, or even a home run, it's fraud. Anything that's legal and ethical can't be more than a good solid double, maybe a triple. So this one I say is a good solid double. If you have a wealthy family, which is going to set up their own private foundation to be the charity, and if they're so wealthy that sending money to their children free of estate gift tax is outside their lifetime exclusion. In other words, in 2026, when the exclusion per couple becomes 12.5 million, if they're going to be worth 30 million, this is an extra million in my example that doesn't count against their 12.5 million. That's pretty nice. So good thing number one, you get 100% deduction. Good thing number two, you pick the charity. It can be a public charity. It can be a donor advised fund. It can be your own private foundation. Ooh, if you're a wealthy person, your own private foundation. That's pretty good. Good thing number one, 100% deduction. Good thing number two, you pick your own charity. Good thing number three, any excess over what you had to earn to pay the charity the $1 million goes to a trust for your children for your estate gift and income tax. You pick all the investments. Yeah, you can do crypto, not 100% crypto. What's the bad thing? The bad thing is, oh, the Charitable Llc trust is a grantor trust. It doesn't pay taxes. It reports the income, but you have to pay the tax. So let's say my $1 million is earning $90,000 a year in ordinary income. The parents have to pay the tax on the 90 grand out of their own pockets. Holy crap. We call that phantom taxable income. Phantom because they're taxed on it, but they don't get the cash. So there's three ways to deal with that. One is you start by putting the $1 million in an insurance policy. Now it's got $1 million of cash value. Every year you borrow out $40,000, pay that to the charity, and there's no taxable income each year. At the end, if your investments work well, cash value will be $2 million. There are insurance policies where you can pick your own investments, private placement life insurance. Use an insurance policy. That's one way to mitigate the bad thing. Okay. Number two, invest in an apartment building. If it's residential, you'll get depreciation that'll at least be 2%. You're not going to earn 9%. Number three, invest in Tesla, Google, Amazon that pays no dividends. You'll sell a little bit every year and you just pay capital gains tax on what it is. So CLATs are really good after the fact to get you a deduction against up to 30% of adjusted gross income. So, and I already mentioned charitable LLCs for cash. So what's the conclusion? Yeah, the conclusion is understand that there are alternatives. There's at least a dozen ways, not for real estate, but a dozen ways in general, depending on the assets, to reduce, defer, or eliminate capital gains taxes. I didn't go through the crown jewels because you got to be careful what we say in public. And timing is the most important element, far and away. So I leave you with the story of, and I don't see any Q&A that we haven't discussed yet, Joe.
I just have one question. When you're done with all of this, are there any times that you tell the client, potential client, pay the tax?
Yep, constantly. So the reason why I charge for my time, I agree to meet with anybody for free for 30 minutes, Zoom, whatever. And during that time, I can understand their goals and objectives, their facts. And then if I'm the appropriate person to help them, I'll tell them that I can and roughly how I can. And I charge after that. If they want to continue the conversation, I tell them it's $2,500 for the first 2 hours. So that's my hourly rate. And after the first discussion, I can send them diagrams. After the second, because it takes at least 2-3 meetings, discussions for them to make a decision. But, you know, in the first 30 minutes for free, you know, when they tell me it's $1 million capital gain, I always say, pay the tax and walk away, you know, unless it's a charitable remainder trust, because if it's $1 million capital gain, it's 330,000 or 371,000. How many of those do you really want to spend 30, 40, 50 grand on planning? You know, there are some people who will, you know, but the other thing you're screening people out for is you explain, you know, audits, penalties and stuff like that. And you can see them. Whereas if they got a letter from the IRS, they would go into immediate depression and need tranquilizers. Well, you don't want them as a client, right? So, you know, you got to screen. As Simon Singer, one of my best referral sources, says, they do not subtract from my paycheck for the matters I don't take. You know, and so we're looking for the right ones. You got to pick your client. Every malpractice carrier tells you, pick your clients carefully, right? So I leave you with the story of two people crossing the country in a hot air balloon. It's so cloudy they can't tell whether they're in Iowa or Idaho. So one guy in the balloon says to the other, let's let some air out of the balloon. We'll coast down through the cloud cover and we'll ask someone on the ground where we are. So they let some air out of the balloon. They go down and they see a guy on the ground carrying a briefcase wearing a three-piece suit. And one guy in the balloon yells, "Hello, down there." And the guy on the ground says, "Hello, up there." And the guy in the balloon says, "Can you tell us where we are?" And the guy on the ground says, "You're in a hot air balloon." And the one guy in the balloon says to the other, "That guy is a tax lawyer." He said, "How do you know?" Because what he told us was absolutely correct and utterly worthless. So I hope I haven't left you in that position today. So as I said, if you want the maintaining dictatorial control using a children's trust, email me. Anything else I said that you like, I have handouts and all sorts of things. So thank you, Joseph. Thanks to the Beverly Hills Bar. Hope you all have a lovely and healthy rest of your day and week.
One more thing, Bruce. There are times that you put on seminars on particular subjects. Is there a way that somebody who would be interested in attending one of those could contact you or your office?
Yeah, we put them on every Wednesday from 2:30 to 4 on different topics. A lot of them are on capital gains strategies in particular. I think the next one is Nevada non-grantor trusts. I think I did 453. I think I've done 754. If you just email me, we'll put you on our email list. And any of the ones in the past, they're all the Zooms are available. If you see a topic that you like that we've already done, you can email Jesus and Jesus will send you the unlock key so you can watch the Zoom that we did. So I've been doing them for 12 years. They're all in the vault.
Big vault.
Okay.
Well, thank you very much. For the people who have attended, who are attorneys, and you will be getting MCLE credit. I think it will probably be something that will be sent out either later today, tomorrow, and it's well worth it. We had a great presentation. Thank you. Thank you, Bruce.
I see one more Q&A.
Oh,
if I can do it.
Yep.
Oh, where do we find those videos? Just email me and I will turn you over to Jesus and you can, they'll send you a list going back many years. If there's a topic you like, Jesus will send you the unlock key. Okay.
Bye all. Thank you again, Bruce.
Thanks. Take care.